Ohio versus Hannah K. Stills, case number 26CR000302. Defendant is present in open court today for counsel, Joseph Funstein. Your Honor, we're here today for a change of plea. On May 11th of 2026, defendant was indicted on 7 counts. It's the state's understanding today that she will withdraw her plea of not guilty and plead guilty to count 2, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a felony of the 4th degree, as well as count 3, possession of dangerous drugs, a misdemeanor of the 1st degree with a forfeiture specification. The remaining counts would be dismissed at the time of sentencing, and the state would recommend a pre-sentence report and drug and alcohol evaluation with sentencing deferred so those may be completed. There's no sentencing agreement, and that is the state's understanding at this time. Thank you.
Is that count 1?
No, count
Count
2
two?
and count 3.
Okay. All right, Mr. Funstein.
Yes, Your Honor, that is correct recitation of the plea agreement that has been reached at this time. Ms. Stills is prepared to enter a guilty plea and withdraw her previously entered not guilty plea to those 2 charges with the understanding of the dismissal of the other charges.
All right, Ms. Stills, how old are you?
I'm 21 years old.
How far did you go through school?
I started nursing school and then I switched to business. I graduated high school. I plan on going back to business school. I am in barber school right now.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
Prescription medication.
What have you taken?
I'm on my, it's called Lesproprom. It's Lexapro. They're the jails. Well,
When did you last take it?
yesterday. Wait, was yesterday Thursday? Yes, yesterday. Yesterday prior before getting transferred over to Lake County.
All right, does that affect your ability to understand what's going on here today?
No, Your Honor.
All right, did you get a copy of this indictment?
Yes.
My understanding, you're going to plead guilty to count 2 OVI of felony 4, and then count 3 possession of dangerous drugs, a misdemeanor 1, as well as a forfeiture specification. Is that your understanding?
Yes.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Mr. Funstein some more, let me know, and I'll give you more time. Do you understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to a trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to be given a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No.
Do you still want to plead guilty to these charges?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes.
You understand by pleading guilty to the felony in count 2, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control. You understand that?
Yes.
All right. In count 2, operating a vehicle under the influence is a felony of the 4th degree, and it carries a mandatory term of local incarceration of 120 consecutive days, and the possibility of additional incarceration. You could get a maximum of 30 months in prison. Do you understand that?
Yes.
I could also place you on community control for up to 5 years. Do you understand that?
Yes.
I will impose a mandatory fine on you. It will be at least $1,540 up to $10,500. Do you understand that?
Yes.
There's also will be an order for mandatory drug and alcohol for a drug and alcohol addiction program. Do you understand that?
Yes.
There's a mandatory driver's license suspension of at least 3 years up to your lifetime. Do you understand that?
Yes.
And if the vehicle that you were operating at the time is in your name, there's a mandatory forfeiture. Do you understand that?
Yes.
In count 3, possession of dangerous drugs is a misdemeanor 1. It carries a maximum jail sentence of 180 days and a maximum fine of $1,000. Do you understand that?
Yes.
If you plead guilty to the forfeiture specification in count 3, you're voluntarily giving up the items listed. Do you understand that?
Yes.
You don't have any question about any of the penalties?
Can you repeat that
Do you
question?
have any questions about any of the penalties?
I don't so.
So you gotta say no.
No.
All right, now I could give you a consecutive sentence on these 2 counts. That means one sentence after another. The only thing that impacts is that I could give you a maximum fine of then $11,500. Do you understand that?
Yes.
Do you understand that on count 3, you could get a driver's license suspension of between 6 months and 5 years?
Yes.
And do you understand? Well, all right. Do you understand that if a prison term is imposed in this case, upon your release, you might be placed on post-release control under the direction of the parole authority for up to 2 years? You understand that?
Yes.
If you are placed on post-release control and violate any of the conditions, the parole authority could return you to prison for up to 9 months for each of the violations, up to 1/2 of my sentence. Do you understand that?
Yes.
You understand that if that violation of post-release control is a new felony, you could get an additional consecutive prison sentence for the violation.
Yes.
The maximum penalty for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand that if a prison term is imposed, you are eligible for judicial release? Do you understand that?
Yes.
I could place you on community control for up to 5 years, but if you violate the conditions, I could send you to prison for 30 months. Do you understand that?
Yes.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk to Mr. Funstein before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this point?
No.
All right, Ms. Cutts, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on March 3rd of 2026, just before 8 p.m., Mentor Police Department officers responded for a report involving a vehicle believed to be parked in the streets in the area of Bronco Court and Broadview Lane in Mentor Lake County, Ohio. A citizen had called in indicating a blue Honda Civic that had a female driving was in that location, and there were concerns about the vehicle occupants. The vehicle was found on the roadway on Bronco Court in front of 7717. There was a female in the driver's seat and a male was standing outside of the vehicle. The male was detained and taken to a police cruiser. The female, who was identified as Hannah Stills, the defendant, when officers went to speak with her, there was an odor of burnt marijuana coming from inside the vehicle. There was a strong odor of alcohol coming from the defendant's person and her breath, and she appeared to be heavily under the influence of alcohol and possibly drugs. There was an open bottle of Tito's vodka in plain view in the cup holder between the driver and front passenger seats in the vehicle. When officers spoke with the defendant, she was somewhat verbally combative with them. When they looked inside the vehicle, in addition to the open container in the defendant's purse, they found a pill container with 7 types of pills. 3 were over the counter, 4 required prescriptions. At least 3 of them she did not have a prescription for. Those that included mirtazapine and prazosin. Both require prescriptions. The eyewitness did confirm that the female was the driver of the vehicle for a period of time. Defendant was transported to Mentor Police Department. She had refused to take standardized field sobriety test. However, she agreed to a breath test, which came back at .229. Through further investigation, it was found that she had prior convictions for operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. She had 3 priors, one being out of Wayne County Municipal Court, case number 24 TRC 005058, with a conviction 2024. Parma Municipal Court, case number 24 TRC 07429, conviction in 2024. And Cleveland Municipal Court, case number 22 TRC 14999, a conviction in 2023. An ORS report was confirmed to show that there were no prescriptions for the 3 of the prescription drugs, all of this occurring in Lake County, Ohio, and that would have been the state's evidence. Thank you.
All right, Mr. Funstein, anything to add to those facts?
Not at this time, Your Honor.
All right, Ms. Stills, did you hear what Ms. Cutts said that the facts would show if the case went to a trial?
What was that? I'm sorry.
Did you hear what Ms. Cutts said that the facts would show if this case went to a trial?
Yes.
Are those facts true?
Are the facts true?
Yes.
All right, what is your plea to count 2, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination, a felony of the 4th degree?
Guilty.
And what is your plea to count 3, possession of dangerous drugs, a misdemeanor 1?
Guilty.
And what is your plea to the forfeiture specification in count 3?
Guilty.
All right, Mr. Funstein?
Your Honor, did you fix the error of the jail time?
Oh, you know what? Joe, let me have that back real quick. Would you have initial, I did that here. I also put in that she took the Lexapro yesterday, okay, just in the margin.
This is best we can. So this is exactly what I gave you. He made 2 changes that he wants you to initial, okay?
Okay.
So one is this, that you took the Lexapro, so if you put your initial right there, can you do that? Okay. And then that's the sentence for an M1, so they made a mistake and put it in M2, so let's put it, yeah, you put it there.
So that's how long?
Yeah.
I'll get it.
So
That's how long.
that's a misdemeanor, that's the max you can get.
Okay.
Yeah, that's worst stuff, which is correct.
Okay.
So you should sign it.
Give me that.
Yeah, go ahead, date it, 7/24. Your Honor, Ms. Stills has signed and initialed at the 2 places you indicated, as well as I have also signed the written plea agreement.
Your Honor, do you want the state to initial as well, or no?
Yeah.
I-
Your Honor, I've received the written plea of guilty and judgment entry. I witnessed the defendant sign document in court as well as initial. Defense attorney has also signed it, and I signed it as well.
All right, Ms. Stills, is this your signature on this written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
All right, I'll accept the written plea of guilty. Defendant was present. Mr. Funstein advised of all of her rights, being a knowing, intelligent, voluntary waiver. She understands the nature of the charge, the consequences of her guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary. I will accept her plea of guilty and find her guilty of count 2, OVI of felony 4, and count 3, possession of dangerous drugs and misdemeanor 1, and the specification. I'll refer this for a pre-sentence report, psychological evaluation. Sentencing will be September 2, 9 a.m. Bond is continued. Anything else, Ms. Cutts?
Your Honor, was the sentencing at 9 a.m. or we were told 2 p.m.?
We were told 2 p.m., yeah.
Okay, let's make it 2 p.m. All right, anything else?
No,
No,
thank you,
Your
Your
Honor.
Honor.
All right.
All rise.